This is Bloomberg Law with June Grasso from Bloomberg Radio.
Today, the Supreme Court upheld a 2017 tax on American-owned businesses' foreign profits, rejecting an appeal that could have saved companies hundreds of billions of dollars. The vote was 7-2, with the justices saying that Congress has the constitutional power to tax people and companies on their share of undistributed corporate income. It's a case that was being watched because of its potential implications for Democratic proposals to impose a wealth tax, but the court skipped that question. Joining me is leading tax scholar David Schizer, a professor at Columbia Law School and former dean of the school. This hasn't been one of the most closely watched cases of the term. Just how important is this decision?
This decision is very important for what it says and also for what it doesn't say. What it says is that many of the international tax provisions that the U.S. government has used to tax income from foreign corporations are constitutional, and that's a very important holding. And at the same time, what it doesn't say is whether something like President Biden's mark-to-market income tax is okay. They haven't told us whether Congress can tax people on appreciated stock when they haven't sold the stock.
Tell us about the facts of this case.
So the Moores are U.S. citizens who bought stock in an Indian company. They have not sold the stock. They have not received a dividend. And so ordinarily, under U.S. law, you don't pay tax until you sell or until you get a dividend. Here, they received a tax bill based on what the foreign company was earning. And this was part of a major U.S. reform effort for corporate tax in 2017. So the Moores said, hey, wait a minute, you can't tax us because we haven't sold and we haven't gotten a dividend. And the court said, actually, you can be taxed. And initially, the court thought they were taking the question of can someone be taxed without a sale, but it's actually not the issue that the case presented. And the reason is that the corporation, the Indian company, was realizing income. And so the court said, well, as long as the company had these sales and was realizing income, Congress could attribute those sales to you. And so basically, this became a case about the relationship between an owner and the business entity, the corporation, instead of a case about whether you could tax an owner without a sale.
Was it an unusual lineup of justices, the 7-2, Thomas and Gorsuch in dissent?
So I think what you have is a division of views about things Congress could do. There is a 7-2 majority for the idea that Congress can treat an owner as the entity for purposes of taxing the owner. You can say, hey, owner, we're going to treat you as earning the income of your entity. And there are 5 justices that say that can be done pretty easily. And there are 2 that say, we think it can be done, but only when there's an abusive situation. And then 2 who say they don't think it can be done. But on this other question of, can you tax someone for appreciation when they haven't sold? There you have 4 justices who've come out saying the answer to that is no, it would be unconstitutional. You have 5 who said, we don't reach that question. One of those 5, Justice Jackson, wrote a concurrence saying, in effect, she'd be fine with it. But as to the other 4, we don't yet know where they are, and that'll be for another case.
So Paul Ryan, the former House Speaker who helped write the legislation, said upending the tax could endanger a third of the U.S. tax code. Do you agree with that number?
The broadest holding here could have cost trillions of dollars to the Treasury. So I do agree. Really, the way the court came out, blesses most of what Congress is already doing. And the questions are much more about what, in theory, Congress might want to do, but they haven't done it yet. So again, the big dollar amounts that Congressman Ryan was probably thinking about were the international tax provisions where U.S. multinationals are taxed based on the income of their foreign subsidiaries. And I think the court today is saying that those rules are constitutional. What Congress has not tried to do, but the president proposed it a few months ago, is to say, hey, you founded this company, your stake is now worth $1 billion, and we're going to tax that income on your stock, the fact that it's gone from 0 to $1 billion, we're going to tax you under the income tax, even though you haven't sold. And Congress has not done much of that. And as for what it's done, there's still a question whether it can. And if it decides to do that, that's still an open question about whether the court would bless it.
Did Justice Kavanaugh, who wrote the majority, did he specifically say we're not ruling on any other hypothetical taxes? We're just resolving the issue before us today?
Yes, he did. And he also made another point. There's another kind of tax, which is, hey, you're rich, and it's not that we're going to tax your gains. We're just going to tax your net worth. That would be a wealth tax. That's the tax that Bernie Sanders and Elizabeth Warren have proposed. And interestingly, Justice Kavanaugh said, we're not deciding that. But he also added there that the government, during oral argument, had conceded that a wealth tax would be unconstitutional. So I think he didn't just note it. I think he sent a signal that he thinks, like the government, that that would be unconstitutional. But the majority is very careful to say this is a narrow decision, and there are a lot of things we specifically are not deciding.
And did the government really concede that a wealth tax would be unconstitutional in the oral arguments?
Yes, they did. There's this idea in the Constitution of a so-called direct tax, and a direct tax is subject to a very unappealing requirement called apportionment, which basically means that the amount of revenue collected from a state has to be the same as its percentage of the population. And if you had to apportion a wealth tax, Bernie Sanders and Elizabeth Warren would have no interest in it, because the net effect of that is that the wealth tax rate would be higher in poorer states. So when asked in oral argument, does the constitutional amendment for income taxes cover a wealth tax, or would a wealth tax be a direct tax? The representative for the U.S. government said that would be a direct tax. So the government did concede that a wealth tax would be unconstitutional unless it was apportioned.
How often does the Constitution's 16th Amendment become a subject of a Supreme Court case?
Extremely rarely. Part of the reason it came up now is because of the conversation in the country about wealth taxes or about an income tax that doesn't wait for you to sell. And because Congress has been considering those steps, I think the taxpayers here brought this case in an effort to give the court the chance to say that those new rules would be unconstitutional. As it turns out, they did not pick their vehicle wisely. They did not pick the right case, because this case really presents a different issue. It's much more about whether you can tax an owner for what the business is doing instead of the business. And that's the narrow basis in which the court resolved the issue.
So who are the winners here? The government, the IRS?
I think it's a win for Congress and the Internal Revenue Service, in the sense that a very important, long-standing body of rules that are designed to protect the U.S. tax base against efforts to move income overseas, I think those rules were blessed as authorized. But on the other hand, there's still a big open question, and in a sense, a mini-win for opponents of these other tax reforms, because the court certainly did not bless them, and we have 4/9 of the court explicitly coming out against them, and heavy hinting from the majority that it would be a different analysis and no one should assume that they're constitutional.
I know you wrote an amicus brief in this case.
We actually said we thought the issue that the court said it was taking wasn't presented, and that instead this was a case not about whether realization is constitutionally required, but about whether an owner could be taxed for what its business is doing. And our theory is exactly the theory that the court adopted.
Congratulations on that.
Thank you.
So does this mean then that $271 billion in tax goes into the U.S. Treasury?
Yes. So the government doesn't have to give that back. But the stakes were much broader, because this was a case about whether, on a one-time basis, Congress could tax earnings in overseas companies. So the one-time basis was approved, but the reasoning the court gave in approving it was this is just like a different rule where there's other overseas income that we've been taxing all the time. And we think that's constitutional as well.
With this decision, is a wealth tax no longer a concern since the government conceded that it was unconstitutional in the oral arguments?
The government can change its position in a future case. So the fact that the government made that concession is not binding. But I think the fact that the court chose to memorialize the concession is a signal of what the current court thinks about the issue.
Thanks so much for joining us today and making tax law understandable. That's Professor David Schizer of Columbia Law School. Coming up next on the Bloomberg Law Show, the Supreme Court has about 19 cases left to be decided within a week that normally ends the term. The vast majority of those cases are on controversial issues like presidential immunity, abortion, guns, social media, and homelessness. Why are some of the most controversial cases of the term being left to the last minute? I'm June Grasso, and you're listening to Bloomberg. The Supreme Court handed down 4 decisions today, leaving 19 more cases to be decided before the end of the term next Friday. Those include at least 14 involving controversial issues, from presidential immunity and abortion to guns and homelessness. Joining me is constitutional law expert Harold Krent, a professor at the Chicago-Kent College of Law, to answer the question that everyone, well, at least Supreme Court watchers, are asking: what's the holdup? First, Hal, they issued 3 decisions in addition to the tax case today, and I have to say they were not high-profile cases that we were tracking.
All 3 cases were criminal law decisions, and they were relatively discrete issues which had divided the lower courts. So the Supreme Court in those 3 cases acted as a traditional Supreme Court would in trying to clarify standards for the lower court. So, for instance, in one case, it had to do with the question of when you can bring a retaliatory arrest claim, which doesn't happen very much, even if there's no probable cause. And the court held that as long as you can show that even though probable cause existed, if no one else has ever been convicted of that offense, then you can bring a retaliatory arrest. So it's a relatively straightforward, traditional decision which commanded agreement of all the entire court. In the Cimarini case, there is a question about whether or not a probable cause exists for one offense for which you have been arrested. Can you nonetheless bring a malicious prosecution charge if you were charged with other offenses for which it was no probable cause? And again, relatively straightforward. The majority of the court decided that a malicious prosecution claim can be brought even if there was probable cause for one charge, but not for the rest. And in an interesting alignment of the court, in the Diaz case, it had to do with the criminal rule of procedure, which says that nobody can comment on an expert opinion on whether a defendant had the requisite mental intent for an offense. In this case, it was someone bringing over clandestine drugs, and the issue was she claimed she was innocent, didn't have knowledge of it, and a FBI official testified that most drug dealers in that situation would not give that quantity of drugs to an unknowing mule trying to, bring over the drugs. And the question at stake was whether that testimony by the FBI has to do with whether, in general, most people would know what they're hauling, or is it too close to saying that in the FBI expert's mind, that person must have known that they were bringing illegal drugs. So the court held that that testimony was allowed, and that produced a bit of a split in the court because of the fact that it wasn't saying that that individual did know that they were bringing over illegal drugs. It just said that most people in that situation would know that they were bringing over a drug. So the court allowed that to come in, and what made it interesting was that Justice Gorsuch joined the dissent while Justice Jackson joined the majority. So in all three cases, criminal cases, the court, again, performed its traditional role of giving guidance to the lower courts in case such cases percolated up again. They don't often, but they do on occasion. And so the court served that role. And meanwhile, we're waiting for the more blockbuster cases that the court has yet to announce.
Every opinion day, I continue to be surprised that the blockbuster cases are not coming out. I mean, here you have the Rahimi case, the ban on guns for domestic violence abusers. That was argued in November. Even if they have dissents and concurrences, should it take this long?
It shouldn't take this long. There may be a strategy, I'm afraid, of releasing many controversial decisions at once. So it sort of like mutes the overall reaction because nobody knows where to start. And so the presidential immunity case, the Rahimi case that you mentioned, the sleeping in the parks case, Grants Pass, may be the same way. And, of course, all of the very incendiary administrative law decisions that have yet to be released. You know, you just release them all together and nobody knows where to start because they're all so important and also controversial. That may be a strategy, or it's perhaps, a justice or two can't finish a key concurrence or dissent, and that's what's holding up the court.
Who decides when the opinions come out? Would that be the Chief Justice deciding that?
Chief Justice does decide that, and so that is a strategy that Chief Justice Roberts oversees. But the question is, will he give a deadline to a fellow justice that an opinion's going out, whether or not the concurrence is ready? That's not generally the case, but obviously the court doesn't want to stay past July 4th. The court may even want to finish by the end of June. So it's getting close where the Chief Justice may say, if it's not in by a certain day, we're releasing the opinion the way it is. That's the leverage that the chief can hold over the fellow justices.
Do you think then that, for example, the Trump immunity case, it's already written, concurrences, dissents, et cetera, and the chief is just holding it?
My guess is that of the remaining 20 cases, there are likely to be several that are all completed, and that for strategic reasons, the chief hasn't agreed to release the decision yet. Wants to sort of stack them out in particular orders over the last couple of opinions days. Not for sure, of course, this is just speculation, but it's given so much time that one would think that there are some of these decisions would have been completed by now.
I've always suspected that, because it's more than strange that the last couple of days of the term we get all these controversial cases at once. And everyone says, well, it's because there are so many concurrences and dissents and, they have to circulate those. But still, it seems like there's got to be something else going on. So right now they have an opinion day scheduled for tomorrow, and they just scheduled another one for Wednesday of next week. And they seem to be doing 3 to 4 cases each opinion day.
Yeah, they've been averaging about 3 to 4 a day. And it's interesting, right, because today's 3 opinions were all in the criminal procedure context. So is that an accident, or did the chief decide to group them together because it made sense thematically? We simply don't know. And obviously, if the court wanted to finish next week, it would have to release far more opinions on day than it has previously, which would lead one to think that they'll probably announce some opinion days for the week thereafter. Just otherwise, they would be releasing at least 6 opinions on a particular day, which is hard to believe.
The justices read from the bench excerpts from their opinion, and then the dissent may read. Is that why it takes so long? Because why couldn't they come out with 5 or so a day?
No, they could. They certainly could. It's just a tradition to try to limit the number of cases released at once. But there's no rule about it, and the court could decide to release 10 decisions, on one day, and it would get everybody scrambling. I don't think that would be the case because that would be a departure from tradition, but it's certainly in the realm of possibility.
All the cases outstanding, many of which are controversial, lead me to think that these decisions are going to be splintered and that you're going to find a lot of maybe 6-3 down ideological lines.
Yeah, I mean, today, again, the cases were relatively discreet. We did not see those kind of traditional 6-3 split, but it is certainly likely that in a lot of these cases, whether it's the Second Amendment case or the First Amendment social media cases or the administrative law cases, not to mention presidential immunity, there may be a traditional split along the conservative liberal fronts, but that remains to be seen. I mean, there may be broader areas of agreement, for instance, on the presidential immunity case. At least that would be my guess from listening to oral argument, but we'll just have to see.
Yeah, and I have to say, I'm surprised about the Rahimi case because I thought during oral arguments that there seemed to be enough justices who thought that, someone with a domestic violence temporary restraining order was the kind of person who shouldn't have a gun.
Yeah, again, to me, the case seems straightforward. If you have a protective order against you because you've engaged in violence in the past, that would be a person to whom we would think, even under the traditions that the court looks to in the Broom case, that would be somebody who would not be eligible for a gun license, depending upon the jurisdiction. But who knows? And we'll find out very shortly.
Okay, so of the cases that are left, besides presidential immunity, which I think is the one that most people are sort of looking for, which do you think is the most controversial?
I think the question of the emergency medicine, whether it can extend to, under the federal guidelines, extend to having an abortion in Idaho is going to be extremely controversial. It's in essence a preemption case about whether this statute overrides Idaho's decision to ban abortions. And I think a lot of eyes will be attuned to that. Obviously, there's also the Fisher v. United States case, which has to do with charges stemming out of January 6th, because it's trying to define what impeding an official proceeding is and whether the rush to the Capitol so qualifies. I think that'll be ones that are focused on. And there's really 3 major administrative law cases up for grabs, and they have the potential of not tearing down the administrative state, but paring it back quite substantially. So I think those will be very controversial as well. Just to add is the whole question about whether the Sacklers were able to settle all the claims stemming from the lawsuits against Purdue Pharma for all the opioids. That has a very practical impact on, many people to whom otherwise might even be able to get more money back for the injuries that they've suffered. So as a practical matter, that's going to attract a lot of attention as well.
Thanks so much, Hal, for being on Supreme Court Watch with us. That's Professor Harold Krent of the Chicago-Kent College of Law. So some of the cases that the court could decide tomorrow involve Donald Trump's claim of presidential immunity, guns for domestic violence abusers, one of the country's strictest abortion laws, fines for homelessness, the regulation of social media, air pollution, and agency power. Coming up next on the Bloomberg Law Show, Nvidia will get a Supreme Court review on a shareholder crypto suit next term. It's the second case involving shareholder lawsuits that the court is teeing up for next term. I'm June Grasso, and this is Bloomberg. The Supreme Court is teeing up cases for next term. It's agreed to use a case over Nvidia's crypto mining revenue to consider making it harder for shareholders to press securities fraud lawsuits. Nvidia is seeking to stop an investor suit that accuses the company of being deceptive about how dependent it was on revenue from crypto mining before a 2018 market turndown. Joining me is Seth Goertz, a partner at Dorsey Whitney and a former federal prosecutor specializing in crypto-related scams. So, Seth, you have cryptocurrency, crypto mining, computer chips. Tell us what this case is all about.
It's certainly an interesting case. I mean, not least because Nvidia just became the most valuable company in the world, I believe, this week. On one hand, it's a very technical question regarding the pleading standard in private securities litigation cases. And so it deals squarely with what a plaintiff needs to prove regarding fraud and scienter to get past the motion to dismiss stage in a securities fraud case. And That is the meat of the legal argument there. Nvidia is arguing that you have to specifically allege the content of internal documents that, in this case, the CEO would have seen that were contrary to public statements that were being made. The plaintiffs in the case are saying, no, not so fast. It's enough that we can infer based upon information the CEO would have known, other things insiders were saying about information the CEO had, to give us a strong enough inference of particularity that he should have known and was making false statements. Those false statements, the crux of sort of the facts of the case, relate to how much of Nvidia's profit was coming from sales of its GPUs, graphic processing units, to cryptocurrency miners. The concern is that amount of profit was not being fully disclosed, and instead Nvidia was, from the plaintiff's perspective, hiding the amount of profit they were making from cryptocurrency miners and just putting it under a catch-all category for gamers.
Please explain what cryptocurrency miners are.
Sure. And so cryptocurrency miners, for instance, Bitcoin, we'll use Bitcoin. Anytime there is a Bitcoin transaction, there are miners, people who use a computer to validate that transaction, to confirm that it's a legitimate transaction and process the transaction. In return for doing this work, the cryptocurrency miners have historically been paid or via Bitcoin in order to do this. Cryptocurrency mining is a very computer-intensive work. It uses an incredible amount of energy, and it's actually terrible for the environment because of how much energy that it uses and how heavy and extensive the computer processing is that's required to allow cryptocurrency mining. It also, from the SEC's perspective, that's an added wrinkle in this case, cryptocurrency mining is problematic because, from the SEC's perspective, the extent to which mining is occurring mirrors the fluctuations in the overall market for cryptocurrency. So if we're taking Bitcoin, the SEC is concerned that if your profits are tied to cryptocurrency mining, then your profits are going to follow the sort of the undulations, the ups and downs of the Bitcoin market. And that is sort of what happened a little bit in NVIDIA's case and why it got hot water with the SEC, and then why this case ultimately arose. Because at its core, NVIDIA, they're just cryptocurrency adjacent. I mean, this isn't Coinbase. They're not a cryptocurrency investment firm. They make computer chips, and they make these GPUs, a computer chip that was initially meant for gamers, but because it is so powerful and because a lot of the computing power that's required for mining is somewhat transferable to the computing power required for high-level gaming, it became very popular among cryptocurrency miners. And so cryptocurrency miners are buying huge amounts of these processing units. And what is the crux factually of the case is whether NVIDIA's CEO knew to what extent a large portion of their profits. The plaintiffs allege that nearly 70% almost of the gaming-related profit that NVIDIA was claiming was actually due to cryptocurrency miners. And from the SEC's perspective, that's a material non-disclosure, and certainly from the plaintiffs, that's what they're claiming is a non-disclosure, because if over $1 billion of your profit is related to and tied up with the cryptocurrency market, in the case of Bitcoin, that could give investors cause for concern given the fluctuations inherent in the Bitcoin market.
So the company said November 2018 it missed its revenue projections and shares tumbled more than 28% over 2 days. NVIDIA's chief executive said, quote, a crypto hangover was to blame. What did he mean by that, and is it believable?
Well, it's certainly believable. That's a statement that I think certainly was part and parcel among why the SEC has been involved. I mean, NVIDIA has settled an SEC regulatory enforcement action specifically related to this issue. I think they paid $5 million for that. And the plaintiffs are clinging to statements like that to show that he knew, essentially what the plaintiffs are saying is the CEO by saying that knew that the fluctuation, the wild drop in Bitcoin around that same time proves that NVIDIA knew that these processing units were being sold to and used heavily by Bitcoin miners, because the reason that their profits dropped so precipitously was because when Bitcoin plummeted, so did the need for miners and all of that work. And so the fact that those sales are so strongly linked, and then you have this CEO statement to the same effect, from the plaintiff's perspective, it evidences their knowledge, CEO's knowledge certainly, that a large portion of these GPUs, graphic processing units, were heavily marketed, sold to, and utilized by cryptocurrency miners.
NVIDIA argued in its appeal that quote, nothing plaintiffs have cited describes the contents of a single internal communication involving Nvidia's CEO that in fact addressed the portion of GPUs sold to cryptocurrency miners. Well, they don't need a single internal document, do they?
No, they don't. I mean, I think that's a little overplayed, and on some level, it's difficult to contemplate how they could get that right now. I mean, they haven't entered into discovery. They don't have access to any of those documents that you would have in discovery. I mean, it's a nice tagline. It's nice and hyperbolic, but it really does, I think, overplay their argument a little bit in that, of course, they don't have documents, and they're not required to state the specificity, the actual contents of a document, but they're required to say, and this is one theory of pleading securities fraud, is that there were or there exist internal documents that would have put the CEO on notice as to specifically the amount of proceeds coming from sales to cryptocurrency miners, and the CEO knowingly and intentionally made statements to the contrary, saying that, this profit is more heavily tied to gaming. And so, the theory of their case, the plaintiff's case, is that there were internal documents, internal information that would have put the CEO on notice. And they do need to provide some specificity as to what those documents would have been, what they would have looked like, how much access the CEO would have had to them. But, word for word quoting a document, from my read, is far beyond what's necessary. But that is something the Supreme Court is going to have to tease out here.
And why do you think the court took this case?
There's a number of different reasons. I think one of them is that you now, on a couple issues related to this pleading standard, like this, for instance, this issue on what needs to be pled about the contents of documents, what's required for fraud and scienter, you are having some of these big circuits, like the Ninth and the Second, coming to diverging opinions. And there was a compelling argument that Nvidia has here in that the Ninth Circuit and the Second Circuit, if they are in fact approaching these differently, those two circuits, handle more than half of the securities fraud cases in the country. It is an enormous number. We have the Ninth Circuit, which is at California, and so you have San Francisco and LA, and you have the Second Circuit, which has New York. That is a tremendous amount of securities litigation being handled by those two circuits, and it is important that they are on the same page. That is a strong basis for doing so. I think it will be interesting to see which way the court goes on this.
As far as shareholder actions, does the Supreme Court have a pattern of how it's ruled in the past or not?
I think that the knee-jerk reaction would be to say that they are going to make it harder to bring these cases. But they haven't necessarily been issuing rulings that just sort of fall in line with what you would assume first. They haven't been issuing sort of down-the-road conservative supermajority type rulings.
I don't recall a lot of cases that they've taken on cryptocurrency.
No, they really haven't. And this is sort of a broader area in which, cryptocurrency and the role of the courts in really kind of legislating cryptocurrency, it has fallen to the courts to do so because cryptocurrency is just far outpacing regulation. Congress is not moving fast at all or even sort of at all to do anything about cryptocurrency. And so you're seeing, for instance, like the SEC getting very involved in attempting to regulate cryptocurrency and declaring it a security, and therefore it needs to be regulated like any other investment. And, like they're embroiled in very aggressive litigation with Coinbase right now. I don't know that the Supreme Court's case here will have any huge ramifications related to cryptocurrency unless the court decides to say, we're denying this. They did plead enough. The plaintiffs have pled enough. And in which case, I could see the court potentially going into, well, here's why they pled enough. Because, cryptocurrency mining, the volatility of the cryptocurrency market is a huge issue. And failure to disclose that information would obviously have an impact on investor concerns, investor confidence in the company. And if they choose to affirm the Ninth Circuit, I could see a situation in which they will have to delve into, to some extent, the facts and what's been pled here. And the crux of that really is like how concerning is like cryptocurrency mining to an investor. And if the CEO has some knowledge of that, withholding it or masking it under another profitability metric, how problematic is that? So all that to say, I don't know that this case will have sweeping ramifications for cryptocurrency like SEC v. Coinbase right now. But it's certainly possible, and I think this represents a trend that we're going to start seeing more and more of, in which as cryptocurrency becomes more mainstream, we are going to see the courts have to weigh in and effectively legislate the role of cryptocurrency in our market economy.
What about the effect this would have on shareholder litigation? Because the court is also going to take a case of a shareholder lawsuit against Meta over the data harvesting scandal involving Cambridge Analytics. So with these two cases, could the court give companies new leverage to win early dismissal of shareholder lawsuits, or the opposite if they rule for the shareholders?
Absolutely. I mean, I think that has been a lot of the talk this week when cert was granted, in that, rarely does the Supreme Court handle anything related to securities litigation, and on their next docket, they're going to have two cases related to this. And certainly there is the potential for them to, change the landscape entirely. And I think you saw that in the amici briefs from the former SEC chairs, who are asking the Supreme Court to reverse the ninth and uphold the district court's denial here and say that there wasn't enough. The pleading standard is quite rigorous, and if the Supreme Court does sort of follow that line of argument, it would certainly change the landscape. In tandem with the Meta and Cambridge Analytica case, there is certainly the potential for plaintiff securities fraud cases to dramatically change.
Next term seems far away right now. Thanks for joining us, Seth. That's Seth Goertz, a partner at Dorsey Whitney. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.